to all. Today the session is about right to education. I would like to start this discussion by quoting Mahatma Gandhi. I quote, "By education I mean an all-round drawing out of the best in child and man, body, mind and spirit." I unquote. This concept of education tends to remove the inadequacies of modern education. The words shiksha, derived from the Sanskrit verbal root shas, meaning to discipline, to control, to instruct or to teach, and vidya, derived from Sanskrit verbal root vid, meaning to know, refers to Indian synonyms of education. Therefore, disciplining the mind and acquisition of knowledge has always been the dominant theme in Indian approach to understanding education. Let me take you to the scheme of presentation as to how the discussion on right to education will be coming up. First, we'll be looking into the significance of education. Then, education, how it was recognized or why is it useful as a human right. Then we move on to the international developments and along with the regional developments that has happened in the field of right to education. Then we will move on to the reflections that we can see with regard to right to education in the Constitution of India. Another area to be looked into is the policies on education within Indian context. Then another area will be the analysis of judicial decisions coming up on the right to education. Then we move on to the specific legislative framework called as Right of Children to Free and Compulsory Education Act 2009, the anomalies and challenges coming up specifically within the legislative framework and also the major deficiencies that we see within the education system in the Indian context. And we'll be ending up with the concluding observations. Let's see how education is understood. Education in its narrow sense is equivalent to instruction imparted in a school or college. Viewed from a broader spectrum, education is a lifelong process through any agency of education, be it a school, house, church, society, the personal experiences, etc., which starts with the conception and ends with death. Why right to education is considered fundamental? Yes, it is considered fundamental because of its multifaceted outcomes. Nelson Mandela once said, "Education is the most powerful weapon which you can use to change the world." Let's see what all are the multifaceted outcomes emanating from this process. It is an empowerment right. As an empowerment right, education is the primary vehicle by which economically and socially marginalized adults and children can lift themselves out of poverty and obtain the means to participate fully within their communities. It is an indispensable means of realizing other rights. It is a powerful tool for the spreading of democratic values, the promotion of human rights, and the attainment of self-esteem and self-realization. Like, we can understand that education has a vital role in empowering women, safeguarding children from exploitative and hazardous labor and sexual exploitation, in promotion of human rights and democratic values, protecting the environment, and controlling the population growth. It is yet another a tool wherein it can be used for defending every child's right to education is one way to advance every child's chance to get at least a minimal level of protection and support as that child develops, treating children with respect and dignity, and building inclusive, participatory and accountable education systems that respond directly to the expressed concerns of all stakeholders will serve to improve educational outcomes. Education is recognized as one of the fundamental social, economic and cultural rights. Let's see how education is a social right first. It is a social right because in the context of community, it promotes the full development of human personality. It is an economic right because it facilitates economic self-sufficiency through employment or self-employment. It is a cultural right too, because the international community has directed education towards the building of a universal culture of human rights. Education is specifically seen as a human right and what it means to be a human right. The right to education, like all human rights, is universal and inalienable. The right to education is legally guaranteed for all without any discrimination. States have the obligation to protect, respect, and fulfill the right to education. There are ways to hold states accountable for violations or deprivations of the right to education. Education takes on the status of a human right because it is integral to and enhances human dignity through its fruits of knowledge, wisdom, and understanding. Let's move on to the international legal developments that was happening in the domain of right to education. Various international organizations such as UNESCO, Economic and Social Council of United Nations, United Nations Committee on Economic, Social and Cultural Rights, and various other forums like World Education Forum in Dhaka, Senegal in 2000, World Conference on Education for All in Jomtien, Thailand in 1990. All these organizations and forums have reaffirmed the human right to education and expressed the framework of obligations and implementation targets for all the states. Now, the right to education, expanded for every child, youth and adult, is considered to be one of the most challenging projects of social development. The UNESCO Convention Against Discrimination in Education 1960 was the first international treaty to be adopted concerning education as such, which provides for standards and equality of education. Article 4 of the UNESCO Convention foresees the state parties to this convention undertake to make primary education free and compulsory, make secondary education in its different forms generally available and accessible to all, make higher education equally accessible to all on the basis of individual capacity, assure compliance by all with the obligation to attend school prescribed by law, to ensure that the standards of education are equivalent in all public education institutions of the same level, and that the conditions relating to quality of the education provided are also equivalent. It mandates to encourage and intensify by appropriate methods the education of persons who have not received any primary education. The Convention also separately determines that rights of national minorities should be given insistent attention as those groups are one of the most vulnerable. In positing a human right to education, the framers of the Universal Declaration of Human Rights in 1948 axiomatically relied on the notion that education is not value neutral. In this spirit, Article 26 of UDHR lays out a set of educational goals. The right to education originally came to be expressed in the now familiar terms for the very first time in Article 26 of the Universal Declaration of Human Rights. Article 26 of UDHR says everyone has a right to education. Education shall be free, at least in the elementary and fundamental stages. Elementary education shall be compulsory. Technical and professional education shall be made generally available, and higher education shall be equally accessible to all on the basis of merit. Education shall be directed to the full development of the human personality and to the strengthening of respect for human rights and fundamental freedoms. It shall promote understanding, tolerance and friendship among all nations, racial or religious groups, and shall further the activities of the United Nations for the maintenance of peace. It is important to note that the right to education was conceived from the beginning as having a qualitative as well as a quantitative aspect. The Universal Declaration implicated that there can be different approaches to the purposes and contents of education. Parents have a prior right to choose the kind of education that shall be given to their children. The provisions of UDHR have been specified and complemented by two later documents. The special document dedicated to education, the UNESCO Convention Against Discrimination in Education 1960, and the International Covenant on Economic, Social and Cultural Rights 1966, which emphasizes the right to education generally, that is, for all people. International Covenant on Economic, Social and Cultural Rights devotes two prominent articles, Article 13 and 14, in the domain of right to education. Article 13 is considered to be the longest provision in the Covenant and is the most wide-ranging and comprehensive article on the right to education in international human rights law. ICESCR, International Covenant on Economic, Social and Cultural Rights, recognizes the right of everyone to education in line with UDHR. It mandates the state parties to agree that the education shall be directed to the full development of the human personality and the sense of its dignity, and shall strengthen the respect for human rights and fundamental freedoms. They further agree that education shall enable all persons to participate effectively in a free society, promote understanding, tolerance and friendship among all nations and all racial, ethnic or religious groups, and further the activities of UN for the maintenance of peace. The state parties of ICESCR recognize that, with a view to achieving the full realization of this right, primary education shall be compulsory and available free to all. Secondary education in its different forms, including technical and vocational secondary education, shall be made generally available and accessible for all by every appropriate means, and in particular by the progressive introduction of free education. Higher education shall be made equally accessible to all on the basis of capacity by every appropriate means, and in particular by the progressive introduction of free education. Fundamental education shall be encouraged or intensified as far as possible for those persons who have not received or completed the whole period of their primary education. The development of a system of schools at all levels shall be actively pursued, and adequate fellowship systems shall be established, and the material conditions of teaching staff shall be continuously improved. Another prominent aspect coming up within the right to education is the 4 A's and its prominence to the right to education. The 4 A's were developed by the first UN Special Rapporteur on Right to Education, Katerina Tomarsky, and adopted by the Committee on Economic, Social and Cultural Rights in its General Comment 13 on the Right to Education, specifically emphasized in Para 6. To be a meaningful right, education in all its forms and at all levels shall exhibit these interrelated essential features. The 4 A's are availability of right to education, accessibility to the right to education, acceptability of right to education, and adaptability of right to education. Let's see in detail as to how these 4 A's work within the domain of education. What is about availability of education? Availability means education is free and there is adequate infrastructure and trained teachers able to support the delivery of education. Functioning educational institutions and programs have to be available in sufficient quantity within the jurisdiction of the state party. What they require to function depends upon numerous factors, including the developmental context within which they operate. For example, all institutions and programs are likely to require buildings or other protection from the elements, sanitation facilities for both sexes, safe drinking water, trained teachers receiving domestically competitive salaries, teaching materials, and so on. While some also require facilities such as library, computer facilities, and information technology. What is accessibility of right to education? The education system is to be made non-discriminatory and accessible to all. And positive steps are to be taken to include the most marginalized. It takes into account 3 forms of accessibility: non-discrimination, physical accessibility, and economic accessibility. Non-discrimination means education must be accessible to all, especially the most vulnerable groups, in law and fact, without discrimination on any of the prohibited grounds on non-discrimination, specifically emphasized in paras 31 to 37 of the General Government. Physical accessibility has to be in tune with the safe physical reach, either by attendance at some reasonably convenient geographic location, example a neighborhood school, or via modern technology, example access to a distance learning program. Economic accessibility means education has to be affordable to all. This dimension of accessibility is subject to the differential wording of Article 13(2) in relation to primary, secondary and higher education. Whereas primary education shall be available free to all, state parties are required to progressively introduce free secondary and higher education. Let's look into some of the obligations to ensure the right to access to education. Right to access to education includes providing free and compulsory primary education, developing forms of secondary education that are available and accessible to everyone, and introduce measures to provide free education and financial assistance in cases of need, providing higher education that is accessible on the basis of capacity by every appropriate means, providing accessible educational and vocational information and guidance, introducing measures to encourage regular attendance and reduce dropout rates, providing education on the basis of equal opportunity, ensuring respect for the right to education without discrimination of any kind of any grounds, ensuring an inclusive education system at all levels, providing reasonable accommodation and support measures to ensure that children with disabilities have effective access to and receive education in a manner conducive to achieving the fullest possible social integration, ensuring an adequate standard of living for physical, mental, spiritual, moral and social development, providing protection and assistance to ensure respect for the rights of children who are refugees or seeking asylum, providing protection from economic exploitation and work that interferes with education. Next component is acceptability. The content, the form and substance of education, including curricula and teaching methods, is relevant, non-discriminatory and culturally appropriate and of quality, and schools are safe and teachers are professionals. Obligation to ensure the right to quality of education includes developing children's personalities, talents, mental and physical abilities to their fullest potential, promoting respect for human rights and fundamental freedoms, and prepare children for a responsible life in a spirit of peace, tolerance, equity and friendship. Promoting respect for the child's, his or her parents and others' cultural identity, language and values. Promoting respect for the natural environment. Ensuring the child's access to information from a diversity of sources. Ensuring that the best interests of the children are a primary consideration. Promoting respect for the evolving capacities of children in the exercise of their rights. Respecting the right of children to rest, leisure, play, recreation and participation in arts and culture. Moving to the fourth component, adaptability. Education evolves with the changing needs of society and challenges inequities such as gender discrimination. Education adapts to suit locally specific needs and contexts. That is the essence of adaptability. Education has to be flexible so it can adapt to the needs of changing societies and communities and respond to the needs of students within their diverse social and cultural settings. Right to education has been reaffirmed in various international treaties, including International Covenant on Elimination of All Forms of Racial Discrimination, 1965, Convention on the Elimination of All Forms of Discrimination Against Women, 1979, United Nations Convention on Rights of the Child, 1989, International Covenant on the Protection of the Rights of All Migrant Workers and Members of Their Families, 1990, Convention on the Rights of Persons with Disabilities, 2006, and the right to education has also been recognized in ILO conventions and international humanitarian law as well as in regional treaties. Let's see how right to education is envisaged under United Nations Convention on the Rights of the Child. Carol Bellamy, she says, I quote, "In serving the best interests of children, we serve the best interests of all humanity." Unquote. UN Convention on the Rights of the Child 1989, Articles 28 and 29 are the prominent provisions on right to education of the child and ensuring concept of quality education to be imparted for the full-fledged development of the personality of the child. The perspectives of United Nations Convention on the Child Rights 1989 regarding the right to education revolves around the basic principle of equality of opportunity. It is mandated that the state parties will have to adopt measures to encourage regular school attendance and reduce dropout. It is not sufficient just to provide formal education. It is also necessary to remove such barriers as poverty and discrimination and to provide education of sufficient quality in a manner that ensures children can benefit from it. Discipline is to be administered in a manner consistent both with the child's dignity and with the right to protection from all forms of violence, thus sustaining respect for the child in the educational environment. The aims of education are defined in terms of the potential of each child and the scope of the curriculum, clearly establishing that education should be a preparatory process for promoting and respecting human rights. This approach is elaborated in the General Comment on the Aims of Education, in which Committee on the Rights of the Child stresses that Article 29 requires the development of education that is child-centered, child-friendly and empowering, and that education goes beyond formal schooling to embrace a broad range of life experiences through which positive development and learning occur. In its General Comment on Early Childhood, the Committee on Rights of the Child interprets the right to education as beginning at birth and encourages governments to take measures and provide programs to enhance parental capacities to promote their children's development. Yet another additional perspective gets into the essence of United Nations Convention on Rights of the Child, as and when it talks about the right to education. It imposes limits not only on the state but also on the parents. It insists that children's best interest must be a primary consideration in all matters affecting them, that their views must be given serious consideration, and that the child's evolving capacities must be respected. The rationale behind parental choice is not to legitimize a denial of their child's rights. Rather, it is to prevent any state monopoly of education and to protect educational pluralism. In the case of conflict between a parental choice and the best interest of the child, however, the child should always be the priority. The right to education thus involves these three principal players: the state, the parent, and the child. There is a triangular relationship between them, and in the development of rights-based education, it is important to bear in mind that their differing objectives need to be reconciled. The Committee on Economic, Social and Cultural Rights observes in the opening lines of its General Comment number 13, education is the primary vehicle by which economically and socially marginalized adults and children can lift themselves out of poverty and obtain the means to participate fully in their communities. The Committee on Rights of the Child highlights the holistic nature of the right to education and underscores the same philosophy set out by the Committee on Economic, Social and Cultural Rights through its General Comment number 13. Article 10 of Convention on Elimination of All Forms of Discrimination Against Women addresses the gender perspective within the domain of right to education. It mandates that the state parties shall take all appropriate measures to eliminate discrimination against women in order to ensure to them equal rights with men in the field of education and, in particular, to ensure on a basis of equality of men and women. The same conditions for career and vocational guidance, for access to studies and for the achievement of diplomas in educational establishments of all categories in rural as well as in urban areas. this equality be ensured in preschool, general, technical, professional and higher technical education, as well as in all types of vocational training. Access to the same curricula, the same examinations, teaching staff with qualifications of the same standard and school premises and equipment of the same quality. It again takes a step ahead in mandating the elimination of any stereotyped concept of the roles of men and women at all levels and in all forms of education by encouraging co-education and other types of education which will help to achieve this aim, and in particular by the revision of textbooks and school programs and the adaptation of teaching methods. The same opportunities to benefit from scholarships and other study grants, the same opportunities for access to programs of continuing education, including adult and functional literacy programs, particularly those aimed at reducing at the earliest possible time any gap in education existing between men and women. The reduction of female student dropout rates and the organization of programs for girls and women who have left school prematurely. The same opportunities to participate actively in sports and physical education, access to specific educational information to help to ensure the health and well-being of families, including information and advice on family planning. We will examine the most important legal documents representing all parts of the world, inculcating the evoked right to education and the most important legal systems and values which talks about this particular right to education are the European Convention on Human Rights 1950, the African Charter on the Rights and Welfare of the Child 1999, the American Convention on Human Rights 1978 and the Arab Charter on Human Rights 1994. The Asian continent and Pacific Ocean region do not have separate special provisions dedicated to the right to education, but international documents are being applied in those states. The first regional document indicating the right to education was the European Convention on Human Rights, specifically the first protocol to the convention. Article 2 of the protocol in general terms briefly foresees that no person shall be denied the right to education in the exercise of any functions which assumes in relation to education and to teaching. The states shall respect the rights of parents to ensure such education and teaching in conformity with their own religious and philosophical convictions. Article 11 of the African Charter on Rights and Welfare of the Child provides that every child shall have the right to education. The provision incorporates aspects of Article 28 and 29 of the Convention on the Rights of the Child. The American Convention on Human Rights is almost similar. The provisions are almost similar to the ones in the International Covenant on Economic, Social and Cultural Rights and the UNESCO Convention Against Discrimination in Education. The Arab Charter on Human Rights, Article 34, states that the eradication of illiteracy is a binding obligation and every citizen has a right to education. Primary education at the very least shall be compulsory and free, and both secondary and university education shall be made easily accessible to all. It should be noted that rights foreseen in this charter are guaranteed only for citizens. Let's now move on to the Constitution of India and see the reflections of the international instruments and how the right to education has come up specifically within the Indian context. India is a signatory to three key international instruments that guarantee the right to education. Universal Declaration of Human Rights, 1948, International Covenant on Economic, Social and Cultural Rights, 1966, and UN Convention on the Rights of the Child, 1989. Before 1976, the Constitution of India has originally defined education as a state subject, while the central government used to play an advisory role. However, the persons who were connected with the educational administration felt that education should be the joint responsibility of both the central and the state governments. The idea was put into practice by a constitutional amendment in 1976. With education in the concurrent list, the centre can directly implement any policy decision in the states. This enables the central government to legislate on matters related to education in the manner suited to it. In 1950, India made a constitutional commitment to provide free and compulsory education to all children up to the age of 14 by adding this provision in Article 45 of the Directive Principles of State Policy with a 10-year limit for the implementation. Though members of the Constituent Assembly knew the importance of universal education, but even then, due to paucity of resources, they could not provide it as a fundamental right, but it was mentioned in Directive Principles of State Policy. Among the various directives touching upon social, economic and political welfare, Article 41 too touches upon the mandate of right to work, to education and to public assistance in certain cases. It mandates the state shall, within the limit of its economic capacity and development, make effective provision for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. Right to education is the only right which finds its place in three parts of our Constitution: fundamental rights, Directive Principles of State Policy and fundamental duties. Article 45 earlier read as, the state shall endeavour to provide within a period of 10 years from the commencement of this Constitution for free and compulsory education for all children until they complete the age of 14 years, which is now substituted by the following: the state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. This was added by the Constitution 86th Amendment Act 2002. The amendment of 2002 also added a clause in the fundamental duties in the form Article 51A Clause K, and it states, who is a parent or guardian to provide opportunities for education to his child, or, as the case may be, what between the age of 6 and 14 years. The 86th Amendment added Article 21A, a fundamental right, which says that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Article 21A of the Constitution of India is a positive right to have an elementary education provided to all children of India, irrespective of caste, class or creed or religion, etc. Every child has a right which cannot be waived off, as doctrine of waiver does not apply on fundamental rights in general. But in case of Article 21A, target citizens are minor children between the age of 6 to 14 years. Hence, state has even more positive duty to enforce children's right to have education. Most important aspect of Article 21A is the nature of education ensured. In this is that it is a basic education at the elementary level that is guaranteed. It is not supposed to be any religious education or any kind of specialized education. Article 21A made the right to education a fundamental right. Unlike other fundamental rights, the right to education required an enabling legislation to become effective. The Right to Children of Free and Compulsory Education Act 2009 was this enabling legislation which came into force on April 1, 2010. With this, India has moved forward to a rights-based framework that casts a legal obligation on the central and state governments to implement this fundamental child right as enshrined in Article 21A of the Constitution in accordance with the provisions of RTE Act. Another provision of the Constitution of India, Article 30, talks about the rights of the minorities and their right to establish and administer education institutions. Right of a minority to establish education institutions is recognized under Part 3 of the Constitution of India in the form of Article 30, which gives the linguistic or religious minorities the following two rights: the right to establish and the right to administer education institutions of their choice. Article 30, Clause 2 bars the state, while granting aid to educational institutions, from discriminating against any educational institution on the ground that it is under the management of a linguistic or religious minority. Let's look into some of the initiatives taken by the Indian government to promote right to education. The first official recommendation for the inclusion of a fundamental right to education was made in 1990 by the Acharya Ramamurthy Committee. The Indian Education Commission, Kothari Commission, from 1964 to 1968, reviewed the status of education in India and made several recommendations. The most important amongst these is its recommendation of a common school system with a view to eliminating inequality in educational opportunities. National Policy on Education (NPE) was introduced in 1968, which was the first official document evidencing the Indian government's commitment towards school education, dealing with issues of equalization of educational opportunity, and sought to adopt a common school system in order to promote social cohesion. There have so far been mainly two comprehensive statements of the National Policy on Education, that is of 1968 and 1986. Subsequently, the National Policy on Education 1986 reaffirmed the goal of universalization of school education and promised to take measures to achieve a common school system. The National Policy of Education 1986 and Programme of Action 1992 lay down the objectives and features of Indian education policy, such as promotion of equality, common educational structure, education for women's equality, adult education, etc. Sarva Shiksha Abhiyan (SSA) was started in 2001 to provide education to children between 6 to 14 years by 2010. The program focuses specifically on girls and children with challenged social and financial backgrounds. The Sarva Shiksha Abhiyan also aims to provide practical infrastructure and relevant source material in form of free textbooks to children in remote areas. Midday Meal Scheme (MDMS) was launched in 1995 to enhance enrollment, retention and participation of children in primary schools, simultaneously improving their nutritional status. District Primary Education Program (DPEP) was initiated in 1994 with an aim to provide access to all children to primary education through formal primary schools or its equivalent through alternatives. Thereby, in 1994, the Ministry of Human Resource Development delegated the task of designing and developing a school-based computerized information system to National Institute of Educational Planning and Administration (NIEPA), New Delhi. District Information System for Education is the first database software created by NIEPA in 1995. This software was again redesigned as per recommendations from Sarva Shiksha Abhiyan to provide computerized data and statistical analysis of the various data. The 11th five-year plan specifically focused on scheduled castes and the scheduled tribes, minorities and rural women, and also on low literacy states, tribal areas, and other disadvantaged groups and adolescents. Universal enrollment of 6 to 14 age group of children, including the hard-to-reach segment. All education guarantee centers to be converted into regular primary schools. All states and union territories to adopt NCERT quality monitoring tools. And the 11th five-year plan also aims to support IGNOU, Indira Gandhi National Open University, existing state open universities, and the states setting up new open universities. The Draft National Education Policy (NEP) 2016 envisions a credible and high-performing education system capable of ensuring inclusive quality education and lifelong learning opportunities for all, and producing students and graduates equipped with the knowledge, skills, attitudes and values that are required to lead a productive life, participate in the country's developmental process, respond to the requirements of the fast-changing, ever-globalizing, knowledge-based economy and society. Let's now contextualize the judicial efforts coming up in the domain of right to education. Bombay versus Bombay Education Society in the year 1955 was a prominent case wherein the Supreme Court considered an order of State of Bombay issued in January 1954 in the light of Articles 29, 30, Clause 1 and 337. The order stated that no primary or secondary school should admit to a school where medium of instruction was English language any pupil belonging to Anglo-Indians and citizens of non-Asiatic descent whose language was English. The Apex Court held that the right to establish and administer educational institutions by minorities may be subjected to states' regulatory power, but such power did not encompass the right to prescribe a particular language as a medium of instruction. Therefore, the circular was held void as violating Article 13, Clause 1 and Article 337 both. The President's reference under Article 143, Clause 1 in Re Kerala Education Bill 1957 was the first landmark case regarding exclusive right for minority educational institutions. In Re Kerala Education Bill case 1959, the Supreme Court observed that the fundamental rights given to all minorities under Article 30, Clause 1 do not prevent the state to insist that in granting aid, state can prescribe certain reasonable regulations to ensure excellence, and that the right under Article 30, Clause 1 is not absolute. Frank Anthony Public School versus Union of India, 1987. The Supreme Court held that the statutory measures regulating the terms of conditions of service of teachers for maintenance of education, excellence and standard were not violative of Article 30. The Supreme Court first recognized the right to education as a fundamental right in Mohini Jain versus Union of India 1992, 3 SCC 666. A great legal breakthrough was achieved in 1992 when the Supreme Court of India observed in this judgment that right to life is the compendious expression for all those rights which the courts must enforce because they are basic to the dignified enjoyment of life. It extends to the full range of conduct which the individual is free to pursue. The right to education flows directly from right to life. The right to life under Article 21 and the dignity of the individual cannot be assured unless it is accompanied by the right to education. The state government is under an obligation to make endeavors to provide educational facility at all levels to its citizens, which was emphasized in paragraph 12 of the judgment. Neither substantial historic judgment by the Supreme Court of India in 1993 radically transformed the status of Article 45. It was J.P. Unnikrishnan versus State of Andhra Pradesh in the year 1993. In this case, the three Articles 41, 45 and 46 were emphasized. And it is in the light of these articles that the content and parameters of the right to education have to be determined. That is what the Supreme Court was enumerating about the right to education. The right to education understood in the context of Articles 45 and 41 meant every child or citizen of this country has a right to free education until he completes the age of 14 years, and after a child or citizen completes 14 years, his right to education is circumscribed by the limits of the economic capacity of the state and its development. This provides a classic example of the good governance approach, whereby the courts try to enforce non-justiciable rights by arguing that since the government has failed to enforce them, it is the court's duty to do so. Both Mohini Jain and J.P. Unnikrishnan cases fashioned a justiciable constitutional right to education by attaching it to the right to life, a right already enumerated in the Indian Constitution. Another proactive judgment bringing out relevance of education in child labour cases was M.C. Mehta versus State of Tamil Nadu in the year 1996. The Apex Court directed the state to design a scheme for providing alternate employment or income to parents of child labourers in order to incentivize schooling of such children, and observe that to develop the full potential of the children, they should be prohibited to do hazardous work and education should be made available to them. In Bandhu Mukti Morcha vs. Union of India 1997 case, Justice K. Ramaswamy and Justice Sajir Ahmad observed, illiteracy has many adverse effects in democracy governed by rule of law. Educated citizens could meaningfully exercise his political rights, discharge social responsibilities satisfactorily, and develop spirit of tolerance and reform. TMA Pai Foundation vs. State of Karnataka, AIR 2003 SE 355, was a case decided by a constitution bench of 11 judges of the Supreme Court, mainly on the question of scope of the right of minorities to establish and administer educational institutions of their choice under Article 30, Clause 1, read with Article 29, Clause 2 of the Constitution. It was held that preserving a small percentage of seats in private educational institutions, aided or unaided, for weaker, poorer and backward sections of the society did not in any way affect the right of private education institutions under Article 91G of the Constitution. The court held that the right to establish and maintain educational institutions may also be sourced to Article 26A, which grants, in positive terms, the right to every religious denomination or any section thereof to establish and maintain institutions for religious and charitable purposes subject to public order, morality and health. In Islamic Academy of Education v. State of Karnataka 2003, the special claim of minority educational institution again came up before consideration before a bench of 5 judges in the Supreme Court. Chief Justice Khare, speaking for the majority, held that the majority ruling in TMA Pai only meant that the law cannot favor majority institutions over minority institutions. He further stated that the meaning of TMA Pai was not that non-minority education institutions would have the same right as those conferred on minority educational institutions by Article 30. He further stated that the special right under Article 30 does confer certain advantages on minority educational institutions. The issues raised in Islamic Academy case were referred to a larger bench of 7 judges in PA Inamdar v. State of Maharashtra in the year 2005 in the Apex Court. Chief Justice Lahoti, echoing unanimous opinion, held that Article 30, Clause 1 was only intended to instill confidence in minorities against any executive or legislative encroachment on their rights to establish and administer educational institutions of their choice. He further stated that Article 30, Clause 1 was styled as a right, yet more in the nature of protection of minorities. The court in this case reasserted the equal rights view. In this case, the Apex Court held that state mandate quotas cannot be imposed in unaided minority and non-minority educational institutions or both. Developments happening in the meanwhile was interesting. Parliament enacted the Constitution 93rd Amendment Act 2005 to undo the effect of above ruling of the Supreme Court in PA Inamdar's case. The said amendment introduced Article 15, Clause 5 in the Constitution, which was purported to enable the state to make provision for reservation of backward classes, scheduled castes and scheduled tribes in government as well as private unaided education institutions. The constitutional validity of the 93rd Amendment Act 2005 came into consideration before the Supreme Court in Ashok Kumar Thakur versus Union of India and others. 2008 6 SCC 1, wherein reservation of seats for socially and economically backward classes was challenged on the ground that it was ultra vires the Constitution. The Apex Court categorically stated that it has become necessary that the government set a realistic target within which it must fully implement Article 21A regarding free and compulsory education for the entire country. The government should suitably revise budget allocations for education. The priorities have to be set correctly. The most important fundamental right may be Article 21A, which, in the larger interest of the nation, must be fully implemented. Without Article 21A, the other fundamental rights are effectively rendered meaningless. Education stands above other rights, as one's ability to enforce one's fundamental rights flows directly from one's education. In the year 2009, the writ petition in Avinash Mehrotra versus Union of India and others, the Supreme Court of India established the link between constitutional right to education and right to adequate environment. The court interpreted the right to education to include the right to the provision of a safe environment in schools and imposed an obligation on schools to comply with certain fire safety precautions which were detailed in the judgment. The court categorically stated that educating a child requires more than a teacher and a blackboard, or a classroom and a book. The right to education requires that a child study in a quality school, and a quality school certainly should pose no threat to a child's safety. This dictum of the court is in tune with the 4 A's developed by the first UN Special Rapporteur on Right to Education, and later adopted by the Committee on Economic, Social and Cultural Rights in its General Comment 13, paragraph 6 on right to education. That is, education should be acceptable, the content of education should be relevant, non-discriminatory and culturally appropriate and of quality. Schools are safe and teachers are professionals. In the case of the Society for Unaided Private Schools for Rajasthan versus Union of India and another, the quota reservation of 25% of school seat for weaker and disadvantaged sections envisaged as per the RTE Act under Section 12C was contested as violative of Article 19(1)(g) and Article 30, Clause 1 of the Constitution of India. The Apex Court upheld the constitutional validity of RTE Act 2009 and also simultaneously held that nothing can interfere with the special rights of the minorities as guaranteed under Articles 29 and 30 of the Constitution of India. Chief Justice S.H. Kapadia in paragraph number 5 in the judgment highlighted that the Right of Children to Free and Compulsory Education Act 2009 has been enacted keeping in mind the crucial role of universal elementary education for strengthening the social fabric of democracy through provision of equal opportunities for all. Premati Educational and Cultural Trust versus Union of India was another prominent case coming up in the field of RTE Act 2009. The Supreme Court was called upon to decide the validity of Clause 5 of Article 15 and that of Article 21A of the Constitution of India, since it was contested that both the provisions violate the basic structure of the Constitution of India. The provisions of RTE Act 2009, Section 12(1)(b) read with Section 2(n) Roman letter 3 insofar as are applicable to minority institutions established under Article 30, Clause 1 of the Constitution are constitutionally ultra-virus. The court held that minority education institutions are a separate class and their rights are protected under Article 30. It was further opined that the minority character of an educational institution may be affected by admitting socially and educationally backward class citizens. In the case of State of Karnataka and another versus Associated Management of Government Recognized Unaided English Medium Primary and Secondary Schools and others. This was a civil appeal before the Supreme Court in the year 2013. The Supreme Court laid down that choice of medium of instruction at primary stage is the right of the child and its parents or guardian, and the state cannot impose the stipulation that medium of instruction at the primary level shall only be the mother tongue of the child. The judgment in NAS Foundation India Trust versus Union of India, writ petition in the year 2014, was another proactive decision from Supreme Court on the issue whether the category of children belonging to disadvantaged groups envisaged under RTE Act 2009 includes children with HIV and AIDS. The Apex Court directed all states and union territories which have not issued the notification to recognize the children with HIV or AIDS as children belonging to disadvantaged groups under Section 2D of the RTE Act 2009 and to issue the necessary notification within 8 weeks. On analysis of various decisions from the Apex Court, it is clear that the performance of the Indian judiciary stands out as a signal contribution to the implementation of human rights generally and that of right to education in particular. Now let's move on to the specific legislative framework, Right of Children to Free and Compulsory Education Act 2009. The passing of the Act marks a historic moment for the children of India. The Act envisages an avowed objective of providing free and compulsory education of all children in the age group of 6 to 14 years as a fundamental right in such a manner as the states may by law determine. The simple understanding is that every child has a right to full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. Let's see the meaning of what is free and compulsory education. The understanding of free education is that no child, other than a child who has been admitted by his or her parents to a school which is not supported by the appropriate government, shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing and completing elementary education. Compulsory education casts an obligation on the appropriate government and local authorities to provide and ensure admission, attendance and completion of elementary education by all children in the age group of 6 to 14. The goals envisaged by the Act can be outlined as bringing children of marginalized sections of our society into the ambit of school education, keeping in tune with the Millennium Development Goals, ensuring that all schools and their teachers meet certain specified norms, and ensuring that all children receive schooling of reasonable quality, free from any form of discrimination. Let's look into RTE Act 2009 and understand the child-friendly approach envisaged within the legislative framework. The prominent features of the Act are: it mandates the right of children to free and compulsory education till completion of elementary education in a neighborhood school. It clarifies what is free education and what is compulsory education. It makes provisions for a non-admitted child to be admitted to an age-appropriate class. It specifies the duties and responsibilities of appropriate governments, local authorities and parents in providing free and compulsory education and sharing of financial and other responsibilities between central and the state governments. It lays down the norms and standards relating inter alia to pupil-teacher ratios, buildings and infrastructure, school working days, teacher working hours, etc. It provides for rational deployment of teachers by ensuring that the specified pupil-teacher ratio is maintained for each school, rather than just as an average for the state or district or block, thus ensuring that there is no urban-rural imbalance in teacher postings. It also provides for prohibition of deployment of teachers for non-educational work other than decennial census, elections to local authorities, state legislatures and parliament and disaster relief. The Act provides for appointment of appropriately trained teachers, that is, teachers with requisite entry and academic qualifications. The Act prohibits 1. Physical punishment and mental harassment. 2. Screening procedures for admission of children. 3. Capitation fee. 4. Private tuition by teachers. And 5th, running of schools without recognition. The Act provides for development of curriculum in consonance with the values enshrined in the Constitution and which would ensure the all-round development of the child, building on the child's knowledge, potentiality and talent, and making the child free of fear, trauma and anxiety through a system of child-friendly and child-centered learning process. Let's see some of the advantages of the Act, which are illustrative in nature. The Act is a welcome step as it provides a much-needed social corrective within the society that has been historically stratified and discriminated on class and caste lines as to access to education. The Act is perceived as a measure to bring more and more children from marginalized sections to the mainstream of the society. The Act fights against discrimination and inequality, the core rights enunciated in the Convention on the Rights of the Child 1989. The RTE Act envisages making all kinds of private schools share the responsibility of educating poor children from the surrounding community. It currently requires participation of private schools by mandatory, free and compulsory admission of children of the poor from the neighborhood at standard first up to 25% of class strength. The Act ensures a socio-participatory process resulting in a decentralized policy of approach in its implementation strategy. An interlinkage of duties and responsibilities of local authorities, parents, teachers and school management committee has been ensured for effective realization of the purpose of the Act. Let's look into some of the anomalies and challenges emanating from this particular Act in text and also in context. They're illustrative in nature. The first prominent one is the environmental attitudinal barriers. The tendency is to judge children's competencies against a set of adult standards, rather than to value what children have to offer as children. The legislation fails to take into account the best interest of the children as far as the education needs of those who are below 6 years of age and were above 15 up till 18 years of age, thus demarcating the age barriers for accessibility to right to education. And this clearly goes against the best interest of the child and the United Nations Convention on the Rights of the Child 1989 principle. Although the Act mandates that private schools set aside 25% of admissions for low-income, underprivileged and disabled students, implementation of this law has not been as smooth as its acceptance. Addressing issues of inclusion for children with disabilities through barrier-free access poses a major Herculean task in the issue of social integration. The obligation to give primacy to the best interest of the children and to ensure their optimum development requires that learning environments are welcoming, gender-sensitive, healthy, safe and protective. Although situations of extreme poverty, emergency and conflict may often impede this, children should never be expected to attend schools where the environment is detrimental to their health and well-being. Schools should take measures to contribute towards children's health and well-being, taking into account the differing needs of the children. This will necessitate measures to ensure that obstacles to health and safety are removed. For example, consideration as to the location of schools, travel to and from school, factors that might cause illness or accidents in the classroom or playgrounds, and appropriate facilities for girl students. The child-friendly approach envisaged in the Act is possible when the quality of teachers and the level of professionalism escalates to a desired level. The proliferation of untrained teachers in the rural areas with less commitment and professionalism adds on to the blight. The problem of uncontrollable mushroom growth of private schools has made it inevitable to put in place clear and transparent policies for the whole range of issues, ranging from specific issues like the dropouts, 25% quota, to larger issues of commercialization of education and regulation of school fees. Minority religious schools need to be brought under the RTE Act. There should be a bridge between Article 21A, which provides a right to education to children, and Article 30 of the Constitution, which deals with the minority educations. Making sure that the larger number of students reach a school is the main focus than augmenting the quality of education. A quantitative approach tends to dilute the noble mission intended and perceived. The lines of solutions implied in the Act are limited to requiring greater parent and local body representation in school managing committees and providing local authorities with the power and responsibility to ensure compliance of schools with specified norms. The mechanisms of monitoring as envisaged under the Act rely heavily on inspections, assessments and punishments with very little support and nurturing of teachers. Unless we bring in sufficient changes in our current approach to both children's and teachers' education needs, we will have more children going to school without the commensurate increase in either literacy or any other form of education achievement. Again, by making local authorities a supportive structure, can call for trends of bureaucratic corruption in admission procedures of children. The much applauded services of the NGOs in the Indian educational scenario have been completely done away within the Act. The question remains as to two contradicting issues. How far the concept of meaningful continuing education enriched with quality can be pursued, and the other, how far the children brought to the mainstream of education are benefited to the maximum through this Act. Dr. S. Radhakrishnan Commission in 1948 pointed out very specifically, I quote, "The most important and urgent reform needed in education is to transform it, to endeavor to relate it to the life, needs and aspirations of the people, and thereby make it the powerful instrument of social, economic and cultural transformation." Given this context of the suggestion from Dr. S. Radhakrishnan Commission, let's see some of the major challenges in the accomplishment of the right to education. To illustrate some of them: inadequately maintained buildings, dilapidated classrooms, lack of sanitation facilities, non-availability of drinking water, libraries and laboratories with no proper maintenance or equipment, availability of qualified teachers, high student-teacher ratio, outdated curriculum and teaching methodologies involving only memorizing of the subject without any understanding of the subject, lack of vocational training and non-availability of such courses that help the students to get employed on completion of their schooling, the long distances to schools, the low enrollment of girls, all adds on to the existing plight of accomplishing the right to education. Adopting a rights-based approach to education is not a palliation. A law is as good as its implementation is effective, despite lofty aspirations. The act to be effective definitely requires higher level of commitment and dedication in addition to large funding and infrastructure. Merely emphasizing on the duties and responsibilities of duty bearers cannot bring out the true meaning of the purpose of the act. A multi-dimensional approach to materialize the intention of the legislation is the need of the hour. The way knowledge is imparted, the atmosphere in which it gets disseminated to the minds of the child, the approach to the child, and the quality is a sine qua non for a well-built, mentally and physically developed child. The contemporary relevance to have a revisit to the right to education and its prospects emanates from the fact that the year 2018 marks the 70th anniversary of Universal Declaration of Human Rights, which was adopted by the global community in 1948. Sustainable Development Goal Target 4 mandates to ensure inclusive and quality education for all and promote lifelong learning. And the main theme of the SDG 2030 stems from no one shall be left behind. Still, realization of the right to education remains as a far-stretched dream. I would like to sum up the whole discussion by quoting Kofi Annan. I quote, "There is no trust more sacred than the one the world holds with children. There is no duty more important than ensuring that their rights are respected, that their welfare is protected, that their lives are free from fear and want, and they can grow up in peace." Thank you.